Just first of all, just to highlight the aims of this session, before we dive in, I just want to highlight what we hope that you can take away from this afternoon. We're going to explore how disability discrimination law applies to dementia and how this intersects with fundamental human rights protection. Dementia isn't always straightforward under discrimination law, so we'll clarify when and how these protections apply. We're going to consider how employers can proactively create supportive dementia-inclusive workplaces. So this isn't just about legal compliance, it's about fostering environments where people with dementia can continue to contribute meaningfully and work with dignity. So our aim is by the end of this session, you'll have both the foundational legal knowledge and also some practical tools to help you understand and advocate for the rights of people with dementia in the workplace. So we anticipate, as Laura said, that this will take approximately 20 to 30 minutes. So we'll leave some time at the end for questions and discussion. So I'm going to pass over to Jill now just to introduce us to the key provisions within the Equality Act.
Thanks. Well, the Equality Act of 2010, dementia is generally recognised as a disability under the Equality Act, so that it's a protected characteristic, and that's because, generally speaking, it fits with the definition in the Act of having a substantial and long-term adverse effect on daily activities. And obviously daily activities include working. And what sort of protection for people living with dementia does this therefore provide? Well, it provides protection from discrimination, harassment and victimisation, and I'll talk a little bit in the next slide about that. It confers a right to reasonable adjustments, and it also a right not to be treated less favourably simply because somebody is living with dementia. And really central to the protections of this Act is the duty on employers to make reasonable adjustments. And they have to take practical steps to remove barriers which are there, which perhaps adversely affect and inhibit a person living with dementia from carrying out their job and working as effectively as they can. And it's one of the most important, or it is the most important protection for disabled workers right across the board. But it only applies, and this is important, if employers know that somebody has a diagnosis of dementia, is living with dementia, or reasonably ought to know about the person living with dementia and the diagnosis. That when we say reasonably, what that means is it's really quite apparent from the way in which the person is operating or certain behaviours, that there is obviously something that is getting in the way of them doing the job in the way that they used to and should be doing. Let's move on to the next slide now. So what's discrimination look like? Well, you can have direct discrimination, and that's treating someone worse simply because they have dementia. So it might be, for example, not letting someone have the same opportunities at work because you know that they have living with dementia, or it's really quite apparent that they're struggling, and this is a likely reason. And it could be not promoting someone, for example, because of their diagnosis, or dismissing someone, firing someone, because of that. Discrimination arising from the disability is prohibited by the Act. So, for example, treating someone unfavourably because of something connected to their dementia. So there would have to be a direct correlation between the unfavourable treatment and an element of the diagnosis and the way in which it manifests itself for that particular person. So an example would perhaps be dismissing someone because they have memory lapses caused by dementia. Or there might be a problem finding one's way around the office, things like that as things progress. harassment, unwanted, which is basically, that's prohibited as well, unwanted conduct relating to dementia that makes the workplace an intimidating or humiliating place. So it makes it, worse, and not a pleasant place to be. For example, colleagues making jokes about some aspects of someone's condition, someone's diagnosis, for example, about memory, or because occasionally somebody may become confused. So that would be harassment. And coming back to this obligation on employers, this duty on employers to make reasonable adjustments. And Lyndsey's going to talk more about what those look like in a few moments. But basically, a failure on the part of employers to make reasonable adjustments can give rise to a claim for discrimination under the Act. So that's not making changes that would help. So, for example, they might be refusing to provide practical help in terms of technology or other sort of tangible things, or introducing flexible hours for medical appointments and etc. It might be that there's another case for other reasons for flexibility in working too. I think the other thing to note here is that a claim for discrimination under the Act is unlikely to succeed if the employer can show that they actively considered and, where it's applicable, offered and implemented reasonable adjustments. What's really important here and employers have to show that they have actively considered and explored reasonable adjustments. It doesn't mean that an employer always has to make adjustments. Reasonable adjustments or adjustments would not have to be made under the Act if they were too expensive or disruptive or impractical for that organisation to implement reasonable. We're talking about reasonableness here, or that the adjustment wouldn't effectively remove the disadvantage to the worker. And this is perhaps particularly applicable to small organisations. But as I said, what's really important here is that there has to be active consideration of what adjustments can be made to enable the person to be able to work effectively, to continue working in that workplace effectively. We'll now look at the human rights that underpin this. So we have these equality rights under the Equality Act, but also human rights are there to support and underpin equality rights. And I think sometimes in the past, there's been a bit of a mismatch between equality rights and human rights, and that they're often dealt with separately, but that human rights definitely support equality rights, and they add weight to those in this country identified in the Equality Act. For example, the European Convention on Human Rights, it highlights the rights to dignity and autonomy and fairness in hearings and processes, and non-discrimination related to someone's particular characteristic, in this case disability, as a result of a diagnosis of dementia. And it applies equally outside of workplaces, but also in workplaces. And across the UK, as a result of the Human Rights Act, the UK public body employers must comply with European Convention rights. And also UK courts and tribunals have to interpret all cases according to the European Convention, insofar as that is possible. And what it basically means is if somebody's European Convention rights are violated, then it's possible to go to a court or a tribunal and enforce those rights alongside your equality rights. And another important treaty here is the UN Convention on the Rights of Persons with Disabilities. And the focus of this convention is all about removing obstacles to equality and removing discrimination for people with disabilities. And again, it emphasises the need for respect for someone's dignity and for their autonomy and their ability to exercise their legal capacity, which is a really important part of your independence and your autonomy, in that someone's views, someone's wishes and feelings, or one's will and preference, as the treaty refers to, must be central and must lead all decisions that are made for and about a person. So it's keeping someone's voice alive at all times. And the treaty also emphasises equality in all aspects of life, including in the workplace. And where someone might have challenges in respect of that, achieving that equality because of their disability, then support should be made available. And the treaty makes that quite specific. Now, it might be supported decision making, support for making decisions, or universal design, or reasonable accommodations as well. And what we're talking about here, when we're talking under this particular treaty about equality, means equality for people with a disability, in the same way, with a comparator as everybody else with or without a disability. It's not saying, well, we allow this to happen for other people with a disability, so it's okay. If it's what the measure is, does this or does this not happen for people without a disability as well? And although at the moment the rights in this particular treaty, this Convention on the Rights of Persons with Disabilities, are not legally enforceable through our courts and tribunals in Scotland, because we don't, in Scotland, the whole of the UK, that doesn't mean that they're not influential, and they should be followed. And indeed, the UK has an international law obligation to give effect to these rights, so they should be influencing decisions at the same time. But I'm now going to pass on to Lyndsey for the next slide and to take over on reasonable adjustments.
Thanks very much, Jill. So I just want to turn to the duty to make reasonable adjustments and just go into a bit more detail on that, because this is one of the most significant protections under the Equality Act 2010. This legal duty requires employers to take positive steps to remove disadvantages faced by disabled employees. So as the slide states, adjustments must be reasonable. Now, what this means is that to consider whether an adjustment is reasonable, we need to take into account the cost of the adjustment, the practicality of it, effectiveness in removing any barrier, and the size and administrative resources of the employer who needs to make those adjustments. So importantly, this is an ongoing duty that continues as the employee's needs change, and that's particularly relevant for progressive conditions like dementia. So the Act defines 3 different types of adjustments that should be considered. A change in the way things are done, such as procedures, policies, working patterns, making physical changes to the workplace, or providing extra support or equipment. But the fundamental question that we must ask with this one is, what are the barriers that this particular person is facing in the workplace? What is it that the employer can do here to remove or reduce those barriers? So what might this look like in practice? Well, it's important to emphasize that adjustments can be often small changes that employers can make that cost very little or nothing at all. But those small or often cost-effective changes can be profoundly significant for the individual concerned. So for someone with dementia, changing how things are done might include moving to a consistent rather than rotating shift pattern, so a consistent shift pattern, a simple scheduling change that costs nothing but provides routine and predictability, providing more frequent structured feedback to employees, reducing time-pressured tasks. These are all cost-free adjustments that the employers could consider making. Physical adjustments could include improved signage, allocating a consistent workspace location, or reducing background noise. Again, often straightforward changes that could make a real difference to someone's ability to function effectively at work. The point is that reasonable adjustments, they need not be expensive or complex, and often the most effective interventions we see in practice are the simplest ones. Equipment and support might include, I think Jill mentioned this, written checklists, reminder apps, the ability to record meetings, record any sessions, or a workplace buddy system. Now, the key is identifying these adjustments through a conversation between the employer and the employee. This conversation will be about the specific barriers that that particular employee is facing in the workplace. And then importantly, actively reviewing those regularly as needs evolve. And so just picking up this point about the conversation, this is foundational. Employers do need to create a safe space where the employee feels comfortable discussing their needs, focusing in on that conversation on not just what the barriers are for that person, but also focusing on what that person can do. This strengths-based approach helps identify meaningful roles and contributions that they can make. And where appropriate, the employer should seek occupational health advice. If there's an occupational health department attached to that employer, they can, of course, provide that expert advice on and guidance on suitable adjustments. When putting adjustments in place, these are practical tips here, but always writing things down from both sides, what's been agreed. So that creates clarity for everyone and provides that record if disputes later arise as to what was agreed in the past. And then, as I said, reviewing those regularly to make sure that they're still fit for purpose. And crucially, employers should train managers to support these arrangements well. Even the best adjustments will fail without properly trained and supportive management. And just being realistic about the process too. Adjustments need to work for the business too, and that's the incorporation of the word reasonable adjustments in there. So they must be reasonable and they must be sustainable. But as I said, the good news is often small changes often make a big difference. Early intervention is important too. So when someone first experiences difficulties at work, implementing those adjustments early on is going to be far more effective than waiting until a situation has become very difficult for that member of staff. I just want to finish up on this by highlighting that if either of the parties are unsure whether an adjustment would work in practice, I always say, well, trial it. Trial it for 2 to 3 weeks, see if it works. If it doesn't work, okay, fine, then move on to alternatives. But at least then both parties have given it a go and see if actually the adjustment does work and removes those barriers. The law does require action here, positive action by employers, but good practice does go beyond mere compliance here with the law. It's about creating that genuinely inclusive workplace where people with dementia feel heard and can continue working with dignity. And a lot of that starts with that supportive conversation about adjustments in the first place. So I'm going to pass on to Connor now, just to talk us through what some of the employment tribunals tell us.
So before I go into to talk about what the tribunals tell us, I want to start with a quick overview of the process. So when a dispute arises in the workplace, then the individual can bring a claim to the employment tribunal, and that's through ACAS early conciliation, as long as that's within the strict time limit. The time limit is 3 months minus 1 day, and that starts from when the incident happens, whether that's through the dismissal or an incident of disability discrimination. but the time limit starts from when the incident happens. And all UK Employment Tribunal judgments are freely available to the public through the HM Courts and Tribunal Service, and the online database contains all available tribunal judgments from 2017 onwards. So currently I'm working on a study with Lyndsey that's an analysis of employment tribunal judgments from the UK, Canada and Australia. And that's using the search terms dementia and Alzheimer's and mild cognitive impairment. And the aim of the study is to see what can we learn from each other, and are there any common problems that people with dementia face across the 3 jurisdictions. So what are some of the common problems? The first one is there is a fear of disclosure. So due to the prevalent stigma currently surrounding dementia, particularly in the workplace, there can be a reluctance to disclose a diagnosis out of fear this could result in discrimination or even a dismissal from their role. I think that could impact like Jill and Lyndsey have already laid out, that employers need to sort of know that if there's a diagnosis where they can start to help. And this stigma surrounding dementia can also potentially be seen in the language used in the tribunal judgment documents themselves, both by employers and also by the tribunal system, particularly around the use of the phrase dementia sufferers, or suffering with dementia rather than living with dementia. And although that's a small thing, that can sort of affect our perception of the ability of someone with dementia to continue in the workplace. There's also the fear of quick dismissals. So people with dementia can often experience the combined double jeopardy of age discrimination alongside disability discrimination. And this can result in quick dismissals out of the preconception that they can no longer remain in the workplace. Whereas I think if employers maybe take a step back and have that conversation with people with dementia, they can have a discussion about, like Lyndsey and Jill said, what are the reasonable adjustments that they can make to try and keep them in the workplace if appropriate for as long as possible. And then that ties into the third problem, which is there's often no real conversation. So partly due to the lack of awareness around dementia, employers can often exacerbate the situation for the person with dementia, even if they might have good intentions. So an example of this is a case from 2022, and it was Mrs. Hutchinson versus Asda. So this is a woman that had dementia that started during the pandemic, and her manager sort of noticed the signs, and even though the dementia diagnosis wasn't disclosed, the workplace tried to make adjustments, but without having that conversation beforehand. So an example was at one point at the end of a shift, Mrs. Hutchinson couldn't find her car keys or house keys, and the manager went through her handbag to try and find them for her. So although that had good intentions, the claimant found that quite demeaning and intrusive. And that highlights the importance of carrying out well-intended support with respect and sensitivity. So basically involving the person with dementia in conversations about them and about their role in the workplace. During the same case, the employer repeatedly suggested retirement to the employee due to her age and the health issues. And under law, this constituted age discrimination and harassment, as these repeated suggestions led to the claimant feeling excluded and emotionally distressed. And the employer failed to recognise that having these discussions should be handled with care to avoid either reinforcing these stereotypes or to avoid making an employee feel undervalued in the workplace. And another common problem is that there's often no ongoing support. So people with dementia can often be unaware of their legal rights in the workplace regarding protections from harassment or their rights to take employers to tribunals. And this can potentially be seen in my current study, as in a search of just under 900 tribunal judgments in the UK, we've only found 40 that are directly relating to people with dementia in the workplace, or those with MCI. So this could imply that cases are either settled outside of court, or that people with dementia aren't aware of their rights under the Qualities Act, or if they're going through the process of getting a diagnosis, they might not have the headspace or the time to try and take something to court within that strict time limit. So what can make a difference? First thing is having, like Lyndsey said, having early, honest talks with employers. to just basically make sure that you're involving a person with dementia in conversations about them, rather than trying to make decisions on their behalf. You can often try and find simple adjustments, like Lyndsey and Jill said. The case, it was the Mrs. Hutchinson versus Asda. They had a few simple adjustments in place in the workplace. So one of them was having an assigned buddy in the workplace. So this is someone that helped to remind Mrs. Hutchinson of the sort of current policies and procedures in place due to the pandemic, like social distancing and wearing a mask. Another one is having shorter work hours or having an amended role in the workplace. Again, in that case, her role was moved from being on the tills to then stocking like a George in the clothing department. So that's something that still kept in the workplace, but it was a role that maybe had a wee bit less pressure, and she was able to be supported through that. Another thing that makes a difference is asking what helps, so having that conversation rather than trying to make assumptions about what could work, and also trying to stay flexible during that process. Would you move on to the next slide, please, Lyndsey? I'm not sure if I can control it from my end or not. Thank you. So where can you find support and advice? The main one is through ACAS Early Conciliation. So you must contact them before you can make a tribunal claim, and this applies across the UK, including Scotland. So we've got the contact details there for them. Assistance and advice can also help, and there's slightly different places to contact them, whether that's for England and Wales or for Scotland. If you're a union member, they're also a good avenue for help and support or advice. And the UK Judicial Office have created a series of explainer videos that are centred on the employment tribunal process and sort of explaining the steps and what this entails. There's a link there for the YouTube channel. And again, for ongoing information and support, you can always contact them, Alzheimer's Society, or there's Alzheimer's Scotland, and they've got their 24-hour helpline. And they've also got dementia advisors who understand Scottish employment law and services and could help to navigate some Scottish-specific resources. I'll pass back to Lyndsey.
Thank you, Connor. This is the final slide, and I'll try and cover this as briefly as I can. But what happens if things go wrong? Well, before you can bring a tribunal claim, you must first go through ACAS Early Conciliation. Connor's introduced us to ACAS. They provide free, impartial, early conciliation services. So when you first notify ACAS of a potential claim, they will then contact your employer or former employer if you no longer work for them, and then attempt to settle the case without the need for you to bring a claim to the employment tribunal. That process typically lasts around 4 to 6 weeks. And the advantage is that it does settle many of the cases, avoiding the stress, the time, and uncertainty as well of bringing a claim to the tribunal. And settlement might involve compensation, financial compensation, that is. It might involve adjustments being put in place in the workplace or any other agreed outcome. Connor mentioned those time limits. They are strict to bring a claim to the tribunal. They're 3 months less 1 day from when from the act which kind of you're complaining about took place. So what you need to do in practice is contact ACAS Early Conciliation within that 3-month time limit. That time limit is due to be extended sometime this year, so watch this space, because 3 months is quite tight. So the law is, fingers crossed, going to be amended to be extended to 6 months. But at the moment, work with that 3-month time period. Tribunals are very strict with that 3-month deadline. And crucially, that 3-month deadline is paused whilst you engage in that ACAS Early Conciliation. So you've got time to engage in ACAS conciliation without running out of time. But what I would strongly advise, if you're an employer or an employee, seek early legal advice, and obtain legal advice as well on what your time limit is to bring a claim. Tribunal system exists there as a very last resort, and as I said, the majority of claims do settle before reaching a hearing. Early advice, early conciliation, and understanding time limits are all critical to protecting your rights effectively. I'm going to finish up there just so we've got plenty of time for questions and discussion, if that's okay.